Welcome to Too Many Lawyers. I'm Royal Oakes, your host. Grumpy Cat and Connor are on special assignments, so I'm flying solo again this week. Welcome to the show. Exciting times for Too Many Lawyers. We're actually morphing. We're entering the video age. I hope you caught last week's video episode where I interviewed Ken Kachigian, author of Behind Closed Doors, In the Room with Reagan and Nixon. And we're launching our special segments, Lawyers with Balls, we call them, because we play pool or ping pong or various other sports involving balls. And our pal Jim Murray, chief correspondent with Inside Edition, is going to be playing pocket billiards with us, along with discussing important issues of the day. So hope you tune in for that one. A lot of inside baseball stuff to talk about today on Too Many Lawyers, starting out with a deepfake law that Governor Gavin Newsom was very anxious to see implemented. He got his pals in the legislature to pass it. And essentially what it said was, if you're in the run-up to an election, 120 days before an election, or within 60 days after the election, and if you go on the web with deepfake stuff, using AI, artificial intelligence, you may be sued. And the thing that motivated it is that there have been a lot of ads and parodies and satirical stuff on the web lately using the power of AI to make people think that a politician is saying or doing something when they really didn't do it. So the law was passed in September, and the very day it passed, a guy filed a lawsuit in federal court to shut down the law. And the guy who filed the suit is a conservative fellow who calls himself Mr. Reagan, but basically he likes to put deepfake parody stuff, satirical stuff on the internet. And what he did was he posted a video of Kamala Harris, and it looks exactly like Kamala Harris, saying, well, I'm the ultimate DEI diversity hire. Well, of course, she didn't say that. And so is there some legal recourse to that? Who knows? But based on this new law, that would be contrary to the law. And so the guy who put it up could be sued. So what happens? He goes into court, as I say, the very day of the law going into effect. And he files a suit saying this is unconstitutional. It's depriving me of my First Amendment rights. And by the way, Judge, I'd like you to issue an injunction to shut down this law. You know what happened? The judge agreed with him. The judge, after a hearing on a preliminary injunction, shut down the law. Why? Because the judge said this is a violation of First Amendment rights. Well, the answer by the state of California was, oh, wait a minute, Your Honor, First Amendment has some limitations. You can't yell fire in a crowded theater, and you can't defame people. You can't say libelous stuff. You can't invade people's privacy. And the judge said, yeah, I hear all that, but if you're going to restrict the First Amendment right to free speech, you have to do it only if there is no other way to rebut or shut down or somehow stop bad speech. And the judge concluded that counter speech is a way to approach this. Counter speech, meaning all the Kamala Harris fans could come forward and say, hey, if anybody's seen this stupid deepfake video where she says she's a diversity hire, that's a big fake and you shouldn't believe it, and so on. The judge felt that that was sufficient, that was adequate. There's also the angle of, well, really, how do you know if something really is a lie? And don't you want to cut some slack to people who engage in parody and satire? So all of these things went into the judge's decision. And of course, that's the trial judge in the Eastern District of California, trial level. The next step is the Ninth Circuit Court of Appeals. And of course, the Ninth Circuit tends to be a little left of center, so it wouldn't be a shock if the Ninth Circuit, maybe down the road a few months, will reject that and turn it around. And of course, ultimately, whoever loses there gets to go to the U.S. Supreme Court. And it might be fascinating to see how the U.S. Supreme Court feels about this issue. In terms of inside baseball procedure, I thought I'd explain a little bit about what we mean when I say injunction. Everybody has heard the word injunction, and you kind of have a general understanding of it. Basically, an injunction is an order by a judge that says, you, sir, or a company, must do something or must not do something. You are enjoined from doing something. It's different from a lawsuit where you say, well, I was ripped off and they breached contract or they defrauded me, and I want money damages. Money damages have nothing to do with an injunction. So you go in and you say to the judge, all right, Your Honor, They filed this law was just passed. And I'm challenging the law. I want you to declare at a trial about 2 years from now, or even more. The Eastern District is about the most congested district in the entire nation. At trial, the state of California says, we think we are going to win. And the other side, who objects to the law, says, no, I think I'm going to win. And what happens is the judge has to make a call now, a month into the life of the lawsuit, almost 2 years before there's going to be a trial. The judge has to decide now if this law should be put on the shelf. And the vehicle is what's called a preliminary injunction. Why is it preliminary? Well, because it isn't issued at trial 2 years down the road. It's issued now a month into the lawsuit. And of course, this judge, in this case, did grant a preliminary injunction. Why? Well, there are two key criteria a judge will look at when deciding whether to grant a preliminary injunction. Number one, the judge asks him or herself, is the guy wanting the injunction likely to win at trial? If he is, that's a real good thing for him. We'll put that on the shelf for him. The next issue is, would there be irreparable injury if the person complaining about the law doesn't get their preliminary injunction now? And the irreparable injury here, of course, would be the violation of their First Amendment rights. And that's exactly what this judge concluded. The judge said, yeah, I think that this guy is going to win. I think the law is flawed, and I think he would suffer irreparable injury. When you hear the word injunction, often you hear of it in terms of like an emergency. Let's say there's a legendary building in town, the Old North Church, and the city council, in all its lack of wisdom, has decided we're going to knock it down with a big wrecking ball. And so the people who want to protect the Old North Church rush into court and they say, Your Honor, we want an injunction right now. And the judge says, well, you filed your lawsuit. We'll get around to you in a year or two. And then, of course, the people who love the church are able to say, yes, Your Honor, but think about it. They're going to knock the church down tomorrow. And so unless you stop that, we're going to have a major problem. Major problem is my iPhone went off, but I took care of that. So that's the nuts and bolts, the inside baseball of the injunction process. And Gavin Newsom is very unhappy, not nearly as unhappy as he was about not being a Democrat nominee for president, but that's a different story entirely. Speaking of Democrats and presidents, let's shift gears and talk about Joe Biden in terms of whether or not he might be inclined to pardon his son based on the tax conviction and the gun conviction. I'd like to give you some advice. Now, I'm no expert gambler, but, there are some sports books, DraftKings and a bunch of others, Las Vegas and elsewhere, and they will take bets not only on sports stuff, but also on things having to do with political events. It's legal in most jurisdictions to bet on the outcome of elections. And where I'm headed with this is, I think you could make a bundle if you go to DraftKings, if you go to Vegas and you bet on, yes, Joe Biden will pardon his son. Now, you followed the drama of Hunter Biden probably, so you know that in general, he was convicted a few months ago by a jury back in Delaware of the gun charge. The gun charge being, if you are a drug addict and you're asked on the gun application form, you're not a drug addict, are you? And if you lie, that's a felony, and he could get up to 17 years in prison based on that conviction. He has not yet been sentenced. He will be sentenced in December for that. As you know, he's got some other legal troubles, namely tax problems. Now, this is across the country here in Los Angeles, where in federal court, he pled guilty. And when I say Hunter Biden pled guilty, I don't mean he did a plea deal. We're all familiar with plea deals where the prosecution leans on a key defendant and says, you really ought to take our deal and testify against the big guys. We really want to go after the big fish. And, maybe we'll work a little something out. We'll give you less of a sentence in terms of a recommendation. It's always up to the judge. Hunter Biden did not do that. He just pled guilty flat out, full stop, as they say. So why did he do that? The argument was, or the idea was, he didn't want to put his family and his dad in particular through the trauma of another very public trial. But here's where I'm headed with this. The president actually hasn't explicitly addressed this question of what he might do in terms of clemency for Hunter Biden or a pardon. Difference being, of course, if you have a pardon, that means that you not only have no punishment, if you're in jail, you're out of jail. If you could be sentenced soon, you won't be sentenced at all. The fines are gone. Everything is gone. No penalty at all. But in addition, if you're pardoned, my goodness, once again, the iPhone will not be denied. If you get pardoned, then the conviction is wiped off of your books completely. It's like it never happened. Now, of course, the fact of the matter is people have good memories, and it's a very public thing, so nobody's going to forget the fact that Hunter Biden had tax issues and gun issues. But officially, it would be wiped. Clemency, on the other hand, is different. Clemency says, okay, no more jail for you, no more fines, but it's still part of your permanent record. It's on your rap sheet. Either way, it would be wonderful news for Hunter Biden. Now, why is it that the press secretary for Biden has been saying over and over, no, he's not going to give clemency. He's not going to give a pardon. It's just not going to happen. Well, maybe that's what the president told her. We don't know what the president told her. But here's my take. After the election, when the political damage and fallout would be minimal, I have a feeling that Joe Biden is going to say, this just isn't fair. I mean, yes, he's my son, but the fact is he was an addict and he has fought through that and he's overcome that. Is it really fair for prosecutors? And by the way, the prosecutor was appointed by Donald Trump. Is it really fair for prosecutors to go against this young man for something that usually, if somebody lies on a gun application, they don't get any jail? And yet some people are talking about 17 years. Now, the fact is, in federal court, sentencing guidelines are such that they do a point system, and there's discretion to a degree on the part of the judge, but the points can be aggravating factors or mitigating factors, and he wasn't a violent criminal. Usually the idea is we don't want to have addicts allowed to have guns because the fact they're an addict means they need money for drugs and they're going to use the gun in the crime. And there's no suggestion that that was going to happen here in Hunter Biden's case. Turning to the tax issue, well, it was pretty spectacular. I don't remember the exact numbers, but I think he basically owed about $1.7 million in taxes over 4 years, 2016 to 19. And during that time, he made about more money than that from who knows where. And he had plenty of money because, according to the government, he spent about $800,000 on hookers and blow. And so that sounds pretty egregious. But again, he's not Al Capone. He didn't shoot anybody up. So the guessing is that he wouldn't get the maximum 25 years in prison that he could get under some circumstances. Still, we're talking about Hunter Biden probably getting something in the neighborhood of 5 to 10 years when you add together both the tax and the gun sentences. Is there any planet on which you would expect that Joe Biden would not pardon his son? Now, you could say, well, maybe it would look so bad for him to do it because it's his son. What about the next president, namely Kamala Harris? Let's assume Kamala Harris becomes president. Is there going to be some sort of deal about pardoning Hunter Biden between the Biden people and the Kamala Harris people? And of course, the mind drifts back to 1974 when Jerry Ford was the vice president under Richard Nixon. Richard Nixon resigned on August 9, 1974. And what do you know? Within about a month or so, he's pardoned of all crimes by Jerry Ford, saying the time is right for the long national nightmare to be over. And of course, we know that Jerry Ford paid the political price. Most people think that he probably lost to Jimmy Carter in 1976 because the pardon was so unpopular. By the way, whatever you think of his politics, happy birthday 2 days ago to Jimmy Carter. He turned 100, defying all the odds, remaining in hospice. But the point is, he suffered a fallout. Therefore, bringing you back to 2024 or 2025, is Kamala Harris going to put up with the fallout of pardoning Joe Biden's son? You know, I don't think there would be much fallout, but I don't think that Joe Biden would really want to put that on her plate. And by the way, you know, she could be incapacitated for some reason. Terrible things happen. Would Walls feel the same way about a pardon for Hunter Biden? So bottom line is the issue is up in the air, but I'll come back to my original point, namely, if you got some spare change, go to Vegas and bet on Joe Biden pardoning his son before he leaves on January 20th. We're going to take a quick pause and we'll be right back on Too Many Lawyers. Welcome back. This is Too Many Lawyers. I'm Royal Oaks. Grumpy Cat and Connor will be back soon. They are on special assignment. So, next question I wanted to pose for you now that we've resolved the issue of whether Joe Biden is going to be pardoning his son. My question is, do progressive leaders realize that when they hate on cops, they're really throwing poor people and people of color who live in underserved, marginalized areas under the proverbial bus? And I want to talk about two cities, one close to home for me, because I live in the Los Angeles area. Let's talk about LA, and then we got to talk about Chicago. In Los Angeles, there's a Metro board. Metro folks are in charge of the buses and the trains, and they don't like police with guns to be on the trains and the buses because they think that amounts to militarizing the transit system. The fact that we have an epidemic of crime, including recently a nutcase literally hijacked a Los Angeles city bus, wound up shooting somebody to death and injuring somebody else. And that's just the tip of the iceberg. People do not feel safe in Los Angeles riding on public transportation. And what's the answer by the woke mayor and the woke city council? Take the guns away, take the cops off the trains, because all we need are ambassadors, unarmed ambassadors with nice coats that people can spot from across the bus and ask questions and so on. It's not helping. There was an interesting comment by one of the woke Board of Supervisors members here in Los Angeles. She said something along the lines of, well, people have different perspectives on law enforcement. Some people don't feel very safe when they see an armed policeman. Really? So that's a reason to get rid of armed cops to make the public transit system better and safer. So that's the Los Angeles report. But the Chicago report, I want to borrow from an editorial by the Wall Street Journal the other day. And this is absolutely stunning. And I think it really exemplifies what I referred to at the top of this story about how the woke are just throwing people under the bus because they want to hate on cops. So Chicago's mayor now is named Brandon Johnson. He lives, according to the Wall Street Journal, in a progressive fantasy land. And the latest evidence is his decision to scrap a contract for gunfire spotting technology that has saved hundreds of lives. He said every gunshot, one of the critics of this said, every gunshot victim left bleeding in the streets of our city will be a worthy sacrifice in the eyes of the mayor for his radical agenda. That was by Chicago Alderman Silvana Tabarez. This was hours before the city's shot spotter contract lapsed. I didn't even know such a thing existed, but it sounds like a good idea. So the mayor has refused to renew the contract and threatens to veto city council legislation to extend it. So what ShotSpotter does is they use acoustic technology to detect gunfire, and then they dispatch law enforcement to the scenes of violence before 911 calls come in. Now, maybe if you're a Tom Cruise fan, you may remember his movie Minority Report, where the precogs are swimming around in a very unpalatable-looking jacuzzi, and they are able, by telepathic means, to alert the cops. Oh, yeah, there's going to be a murder down at the corner of 1st and Main in about 14 minutes, so you better hustle down there and rappel through the window. That was fiction. This is reality. This is a situation where we can dispatch the cops to the scenes much faster than ever before. And the University of Chicago Crime Lab estimates that this saves 85 lives a year. The system has detected over 200,000 gunshots in the last 13 months. Even the mayor, according to the Wall Street Journal, must think the technology works, because in February, he extended the contract through the summer, which is when gun violence typically peaks. And by the way, the city was hosting the Democrat National Convention. But last week, the mayor decided, I'm going to let the ShotSpotter contract expire, calling it a waste of money. He might be taking cues from the brilliant Elizabeth Warren, senator from Massachusetts, who said in May of this year that ShotSpotter perpetuates over-policing and unjustified surveillance in minority neighborhoods. Really? What's unjustified about spotting gunshots that can result in saving at least 85 lives a year? So the city council disagreed with Elizabeth Warren and voted 33-14 to give Chicago Police Superintendent Larry Snelling the power to override the mayor's office. If one life is saved with gunshot detection technology, it is absolutely worth saving, according to Alderman Ray Lopez. Alderman Brian Hopkins, chair of the council's Public Safety Committee, is threatening to go to court to keep ShotSpotter. It's tempting to say the people of Chicago are getting the progressive rule they voted for, according to the Wall Street Journal, but nobody deserves this mayor of mayhem. All right, let's shift gears to talk about everybody's favorite topic these days, Sean Diddy Combs. So he's in a heap of trouble because of the federal indictment over the freak-offs and the alleged sex trafficking, and he's basically being pictured as a crime mob boss. When his defense, of course, is, hey, I don't have the same kind of parties as most people, but it was all consensual. Nobody was kidnapped. There wasn't any arson. There wasn't any violation of the law. Just talked to these people. So the news now is that there's a lawyer in Texas, and somebody has to explain this to me, how he's doing this. I mean, some people are better at marketing than others, but this lawyer in Texas just announced a couple of days ago, he is representing 120 victims of sexual assault or sexual abuse by Sean Diddy Combs. So the question is this going to be even more bad news for Sean Combs, or is it just sort of a speed bump, given the fact that he's looking at a federal indictment that could put him in prison for the rest of his life? And I think the answer is this could really be huge. As we know from cases involving Bill Cosby and Harvey Weinstein, when you have a limited number of victims, there can be credibility issues, because oftentimes the victims tell conflicting stories. And oftentimes the victims are looking for a payday of their own, not just a prosecution of the guy who allegedly victimized them, but they're suing for money damages. And so the defense is able to say, well, isn't this convenient? These so-called victims never told the cops that they were victims. They never memorialized it in any kind of writing or recording or photograph. They never told anybody at the time that they were a victim of illegal activity. And what do you know? They're looking to get really, really rich. And so as a result, that can be a very tough job for the prosecution to convince a jury that these people really are credible. Again, you think back to the Bill Cosby situation, where the woman Andrea Constant alleged that he did his usual thing that all the other witnesses later talked about, namely, he drugged her with a Quaalude or some other medication, and when she wakes up, he's having sex with her. So the defense was able to show at the very first trial involving Bill Cosby that, isn't it strange that she didn't report this to the police, she didn't memorialize it with any records, and then between the time that this allegedly happened to her and the time that she did report it and file a lawsuit seeking millions of dollars, she and Bill Cosby were very friendly. She gave him gifts. She reached out when he was doing a comedy concert up in Toronto and said, hey, Bill, could you get tickets for me and my parents? We want to come up and see you. And the defense is able to say, are you kidding me? If she really thinks that he raped her, is she going to behave in this way? Now, defenders of her and some psychologists and psychiatrists say, it's not that weird. Some people deal with trauma in this kind of way. They sort of repress it. It isn't exactly a repressed memory, but it's something that they force down so low in their psyche that they behave in a manner that's inconsistent with the way you would expect a victim to behave. Well, we all know what happened to Bill Cosby. Eventually, he was convicted, and then the Supreme Court of Pennsylvania let him out because they felt that the district attorney, who years before the criminal case was filed, the DA who promised Bill Cosby, I won't prosecute you if you will just not take the fifth, give your deposition in this Andrea Constant civil case. And Bill Cosby said, okay, it's a deal. And so he did that. Then he settled the civil case. And then years later, when a rival of that district attorney is now the DA in that county in Pennsylvania, he said, I don't think that agreement was enforceable. I'm not going to stand by that. And so I'm going to prosecute Bill Cosby. And sure enough, he was convicted. Well, the Supreme Court of Pennsylvania said it really wasn't fair. And so Bill Cosby is now a free man. So that's what happened in his case. Bringing it back to Sean Diddy Combs, I think the effect of 120 people coming forward, even though you can say, well, they all want a big payday, but the law of large numbers, which is an insurance concept, irrelevant to this, but it sounds like it relates. When you have that big a group of people making these allegations, I think it convinces the general public, and that includes future jury pools. I think it convinces people that this isn't just a crock. This isn't just some greedy people looking for a payday. There's something really serious there. I'm still wondering, though, how in the world this guy was such an incredible marketer that he was able to get 120 clients. That's going to be a giant payday for his Texas law firm. All right, next topic. Are you surprised that this guy, Ralph, R-U-T-H, who was thinking about shooting Donald Trump at the golf course in Florida, are you surprised that he has been charged with attempted murder? And the reason I say that is to charge somebody with attempted murder, they have to demonstrate an act showing substantial preparation, not just thinking about it, not just, buying a bomb or a gun or something. You have to take specific steps. Attempted murder, of course, by definition, is he didn't actually murder, didn't necessarily even shoot the gun. But before the letters emerged by this Ralph fellow to some friend, where he basically said, yeah, I want to assassinate Donald Trump. And by the way, if I fail, I'm going to put up $50,000 to the government of Iran or whoever else has the good sense to do that for me. Before that emerged, there was no charge for attempted murder. So the interesting question in my mind was, before the letter emerged, would the government have been able to get away with charging him with attempted murder? Because remember, the initial charges weren't murder or attempted murder, that is. The initial charges were that he possessed a gun, he had no right to have it, and also the gun, somebody tried to obliterate the serial number. I can imagine that a clever defense lawyer could have said, if this letter hadn't emerged saying, yeah, I was trying to kill Donald Trump, he could have said, well, this is not an attempted murder case. It's a much smaller case, so he should get fewer years behind bars if he's convicted. Because, yes, he was very stupid to go there at 1 a.m. with his food bag and his backpack and his rifle. Yes, he was very stupid to stay there for 12 hours. And then, of course, talk about stupid, he waits until the Secret Service agent, whose job it is to be one hole ahead of Donald Trump on the golf course, waits till the Secret Service agent is in the vicinity to point his rifle through the tree line, at which point the guy sees him, shoots at him, he runs away, leaving the food bag. And fortunately, a citizen happened to take a picture of the Nissan truck driving away containing Ralph. And of course, he knew something was up because the citizen witness heard the gunshot. But it could very easily have been the case that this guy could have escaped, because if he hadn't been spotted by a passerby, he would have just melted into the interstate, gone north up the highway in Florida. And of course, he also could have just abandoned his car that had the license plate from the picture 5 minutes away and just headed into the 7-Eleven or chilled in Starbucks for 5 hours. Thank God criminals are stupid, but he didn't do any of that. But a lawyer could say, he didn't really want to kill Donald Trump. He just wanted to wing him, or he just wanted to scare him. And he never got a shot off. He never even saw Donald Trump because Donald Trump was 440 yards away on another hole. Bottom line, though, is that he is being charged with attempted murder on the strength of the letter that he sent to his friend. And by the way, some people think his friend might be in a little trouble because apparently it was one of these deals, do not open this unless, you hear about my death or I'm in the news or something like that. I don't know how it was worded. And so some people are second guessing the guy and saying, gee, maybe you probably knew this guy was a complete bonkers nutcase. Why didn't you open it up and alert the authorities? And you would have saved a lot of people a lot of trouble. All right. Finally, let's talk about the Jack Smith filing in Washington, D.C. In the case, the January 6th case against Donald Trump. Just to give you the quick background, of course, because you need a scorecard to keep all the Donald Trump cases straight. 4 criminal cases against Donald Trump. The Mar-a-Lago documents one, that's gone because the Trump appointee judge, Aileen Cannon, dismissed that case, saying that Jack Smith was illegally appointed as prosecutor. Then we know Stormy Daniels resulted in the conviction up in New York City. And the third case, the Georgia case, that's still a big kerfuffle over whether Fani Willis, the district attorney, should be out of there. That's up in the appellate process in Georgia. So that leaves the fourth and final criminal case against Donald Trump, the January 6th election interference case. You recall the background. Donald Trump filed a motion to dismiss this case, arguing, hey, Judge Tanya Chutkan, I know you may not think much of me, but the fact of the matter is I was president when all this happened on January 6th, and president is immune from prosecution, so please dismiss the case. She said, nice try, Donald. Actually, no, it wasn't even a nice try. It was a try, and so she denied the motion. So Trump takes it up to the D.C. Circuit Court of Appeals, and what do you know? The D.C. Circuit Court of Appeals said, same thing Judge Tanya Chutkan said, you tried, but you failed. There's no immunity. We're not even talking about immunity. Now Trump goes up to the U.S. Supreme Court, and we all waited and held our breath and heard on July 1 of this year, a day after they were supposed to leave and head for their summer vacation, Chief Justice John Roberts wrote the opinion for the court, and he said, you know what? There is immunity for a president. These lower courts were wrong when they said there was no immunity. And here's how the immunity rule works, according to Chief Justice John Roberts' majority opinion. A president has basic core constitutional fundamental duties, like appointing an ambassador or issuing a pardon or asking the Congress to declare war. And if you try to prosecute a president for doing one of his core basic duties, sorry, you can't, because he's immune. Now, the presidential life involves not just core constitutional duties, but a lot of federal presidential duties that are sort of in the penumbra or the outer edges of his job description. And yes, some of those things might result in a prosecution. The presumption is that you may not prosecute somebody, but it's a rebuttable presumption, meaning that the Jack Smiths of the world can come along and say, hey, you know what? Yeah, it was sort of a semi-official duty that Donald Trump had, but we think that it's in that penumbra where you should be able to prosecute him. So that's what the U.S. Supreme Court said. This is the new rule. And then the punchline is, Judge Tanya Chutkan, here's the case back in an icebox. You now have the job of figuring out, of all the allegations by Jack Smith against Donald Trump, which of them go into the personal bucket and which of them go into the official acts bucket. And once you sort that out, then, of course, whoever doesn't like your opinion can come back up to us and maybe we'll help out again. So that's what has been happening over the last few months. And Judge Chutkan said to the parties, okay, I want you to file briefs explaining, what you think is remaining in terms of allegations against Donald Trump and in what bucket they belong. And so yesterday, a 165-page document came in from Jack Smith to the judge saying, oh, Judge, look at all these things. And some of it was old news, but some of it was kind of a new spin. For example, there was an aide on a helicopter ride where Donald Trump and his family were riding while he was president. And basically he said, I don't care whether we win or won the election or lost. You have to fight like hell no matter what. In addition, there was an aide who came to Donald Trump on January 6th when Mike Pence was in danger at the Capitol. And the aide said to Donald Trump, Vice President Pence is in peril at the Capitol. And according to the filing by Jack Smith, Donald Trump said to the aide, so what? There were a few other items like that. And so this was the attempt by Jack Smith to say to the judge, that personal bucket is full. Now, the Trump side will have their opportunity to respond. And we know basically what they're going to say. They're going to say, look, a president has a lot of job duties. One of the job duties is to enforce all federal laws, including election laws. And Donald Trump had a sincere belief that he'd been ripped off and defrauded. And so he was just taking steps that he had been told by counsel were the appropriate steps. And he asked Mike Pence to do the right thing. You want to be known as a patriot, not some other P word. And that's going to be his defense. And of course, Jack Smith is going to be able to point to the fact that Donald Trump knew he'd lost 60 lawsuits in a row. And allegedly, he said to people, I know I've lost, but I'm going to keep fighting anyway. So that's the fight that has to go forward. As to when it's going forward, well, there's no way this judge in D.C. can make any kind of final decision before the election. So we're going to have more briefing. We're going to have an oral argument. And eventually, probably late November, December, or January, the judge will issue a decision saying, okay, this is the personal bucket, and yes, Jack Smith, you may prosecute him for that. But a final question people are asking is, what about the issue of the Department of Justice not interfering with an election? There's an informal, unwritten rule at the Department of Justice. Again, it's not written down anywhere, but the informal rule is called the 60-day rule, meaning if you get to the point where you're 60 days out from an election, so basically September 5 or so, the DOJ should not do anything that will interfere with an election. For example, you shouldn't be indicting political figures or their close allies. For example, you shouldn't be launching in a public way some new special investigation that might make people think, oh, this guy who's running for office, he must be a criminal. The DOJ is after them. So that's a reason not to have a specific act by the Department of Justice in this window of 60 days before the election. And so some people are criticizing Jack Smith and Judge Tanya Chutkan, who agreed to release and unseal the 165-page document. Probably the Trump folks are going to lose that argument because not only is this an unwritten rule, the fact of the matter is this is not an indictment and it's not launching a special investigation. It's part of an ongoing process where Donald Trump's activities on January 6th and around that time frame are being tested by this prosecution. All right, that's going to do it for this edition of Too Many Lawyers. We'll see you next week. Have a good one.